Howdy, and welcome to the South Texans Property Rights Association's first in its webinar series dealing with landowner liability. I'm Eric Opiella, Vice President of the Association, and I'm happy to have a panel of very distinguished guests here today discussing these issues and able to answer your questions related to landowner liability. STPRA was formed in 2006 in part because of concerns for landowner safety, landowner liability, and property damage caused by border security and immigration issues on private property. To this day, landowner liability remains one of the important issues to the association, along with the other issues that are monitored and priority issues that are listed on your screen. Due to an incident on the Jones Ranch, the ranch of one of our members of South Texans Property Rights Association, a lawsuit was filed called Beaujean versus Rodriguez. This is when a Border Patrol agent chased a group of illegal aliens onto our member's property. This led to a lawsuit when the vehicle flipped over and killed some individuals on the ranch that is one of our members' property. This led to a concerted effort by STPRA in 2009 along with State Senator Chuy Hinojosa to pass Senate Bill 1153, which limits liability per statute to a landowner whose livestock escaped due to an act or omission of a peace officer or firefighter, and in 2011, Senate Bill 1160, which strengthens and broadens landowner protection as it was originally intended to protect against actions from peace officers or federal law enforcement officers when an officer enters or causes another person to enter agricultural property with or without the permission of landowners, lessees, or occupants. We have also requested an Attorney General opinion which clarified that the duty of care for trespassers would apply to the federal Border Patrol actions on people's property. And just as recently in Garza versus Pruski, which is one of the cases that's going to be discussed later on in this webinar, we authored an amicus brief to the Texas Supreme Court, along with other landowner associations, to ensure that when cattle escape from landowners' property, that the appropriate standard of care exists to limit the liability of landowners. So if you're not a member of STPRA, we urge you to join. STPRA gives a voice, as you can tell from the legislation that I just mentioned, to landowners to address their needs in South Texas and beyond, both in our state capital and in our federal government as well. You can go to stpra.org, that's stpra.org, to join and learn more about the association. Well, without further ado, I'm going to introduce our first panelist. Professor Tiffany Dowell-Lashmet is Associate Professor and Extension Specialist in Agricultural Law with the Texas A&M AgriLife Extension. She focuses her work on legal issues affecting Texas agricultural producers and landowners, including agricultural leases, water law, oil and gas law, eminent domain, easements, and landowner liability. She speaks at various programs across the state and country, as well as authoring the award-winning Texas Agricultural Law blog. I subscribe, and you should too. Also hosts the award-winning Ag Law in the Field podcast, which is available on iTunes, Stitcher, or any other place you can get podcasts. She lives in the Panhandle with her husband and 2 young children. Take it away, Tiffany. Thank you for being here today.
Great. Thanks for having me, Eric. I'm thrilled to be here. I always enjoy anything that the STPRA does. You all do great work for landowners in Texas, and I'm excited to be here. We're thrilled to have so many on the webinar. I see several familiar names, and so I think this will be really fun. One thing that I mentioned is we are going to allow question and answers to be done at the end of the webinar. So as we go along, if you've got questions, type those in the chat box. We won't be opening up microphones for people to ask them. Just from a logistics standpoint, that can be a little bit of a nightmare. But we'll type questions in at the end to make sure we have a chance to answer those. So with that, let's get started. I have to give a little disclaimer when I speak. I am a lawyer. I'm not your lawyer, which basically means I'm here to give you some general information today. I do offer any legal advice, and if you advice, you'll want Okay, so the first thing I want to mention is just sort of a list. A lot of these liability presentations, and I've come up with this list of 5 steps that landowners or occupiers of land, such as lessees, can do to protect themselves from liability. You'll see this list here. We're not going to cover all 5 of them. I have a fact sheet that lists those out. I'll make sure to show you at the end of my presentation how you can find that. And I will see if we can at the end of the program today. So just quickly to look through these, the most important thing you can do to protect yourself from a liability perspective is to have liability insurance. And our next speaker is Chris. He's going to talk all about that for part of our program. A second step is to identify dangerous conditions on the land and either warn people about them or make them safe. A third thing you can do is consider written liability waivers for people on the property. That's particularly applicable when you're dealing with people that are there for a recreational use, such as hunting. You can consider setting up a business entity structure. There are some different business entities that are like an LLC, a corporation, and ensure that the apply your office. May not be familiar with those, and what that is essentially is statutory limited liability that the legislature has created to protect agricultural landowners. We're going to talk about a couple today. These, you can go do some Googling or some looking on my blog or podcast to learn more. There's Texas Agritourism Act and the Texas Farm Animal Liability Act. So again, the Recreational Use Statute, the Agritourism Act, the Farm Animal Liability Act, Texas landowners, and great statutory protections available to you as well. Okay, let's look at a case called Garcia versus Pruski. Okay, Eric is telling me audio is not great. I tell you what we're gonna do. We're gonna turn my video off and see if that helps. I'm also going to grab a headset. So give me 1 second.
We're going to see if that works better. Nothing like troubleshooting in the middle of a presentation to keep you on your toes. And so if we look at the, like I say, the Garcia versus Pruski case, this is a case recently that came out of the Texas Supreme Court. Hugely important opinion for Texas landowners. Give me 1 second here. Hold on 1 second. I have no idea what just started playing, so if you heard that, I don't know. Okay, let's get back where we are. Garcia versus Pruski, hugely important case for Texas landowners. Here's the facts. A bull got out on a highway in Wilson County and it was hit by a motorist. The bull was in a pasture next to the road. The gate was latched and there was a lock present, but that day the lock was not engaged. They had left the, padlock unlocked, but the gate was latched, okay? The owner rarely had cattle get out, and in fact, only one time in the last 10 years had he had one cow escape. There was no cattle guard on the property. So after the collision occurs between the motorist and the bull, the motorist files a lawsuit against the owner of the bull. And he essentially claims negligence, that the landowner violated his duty to keep his animals in, right, to fence in that bull. So the question was, is the bull owner going to be liable? So I want you to think about that, all right? Think about these facts. Think about what you know on Texas law. And think, do we think that that bull owner is liable? I'm going to do a very basic overview of fence law because I think it's important for us to understand liability. In Texas, the starting point for any fence law issue is whether the area is open range or closed range. All right, an open range area means that it's the obligation of the neighbor to fence out another person's animals. Sometimes you'll hear that called a fence out area. Closed range is the opposite, okay, and in a closed range area, it is the obligation of the animal owner to fence the livestock in. So you'll hear that called fence in. And so obviously when we're dealing with liability, it's really important to determine which area you're in. And so here's where it gets tricky in the state of Texas. The general rule is that Texas is an open range state. However, that can change by either statute or by local election. And in fact, in many areas of the state, that has changed, okay? So there are really kind of two changes that make a lot of Texas be closed range, all right? So the first is, if you have an animal that gets out and gets hit on a state or U.S. highway, all state or U.S. highways in Texas are closed range. That's going to be like Highway 6, I-40, okay? That's not going to be farm to market roads. If you look at the definition, it doesn't include farm to market roads, okay? And so if you have an animal that gets hit on a state or U.S. highway, what the law says is that the landowner cannot knowingly permit the animal to run at large. In other words, if you knowingly permit that animal to run at large, you can be liable. If you do not knowingly permit it, then there's no liability. So that becomes a factual question we'll talk about in just a moment. The next question has to do with, or the next exception has to do with local stock laws, okay? And what the local stock laws do say, basically, each county has the right to hold an election where the local landowners can vote to change either all or some portion of the county from the general open range to closed range. And if there is a local stock law in place, the standard for a landowner says that the landowner cannot permit the cattle or the livestock to run at large. So you'll see here, even in a closed range area, there's a difference in the standard. For state and U.S. highways, the standard is knowingly permit. For local stock laws, which would apply to farm to market roads or county roads in those counties that have passed them, it's a lower permit standard. Okay, so two things just kind of baseline for you all to take home and do. The first thing is you need to know the answer for your county. Does your county have a local stock law or not? You have to know that to know what your duty is, okay? I would recommend starting with your county extension agent. I've been harassing them for a couple of years now to get that information to me in hopes that I can make a website for the entire state. Check with them. You can also check with your county judge, county sheriff, county attorney, and hopefully they can help you track that down, okay? The second thing that you want to do, and I think that Chris is going to talk more about this, make sure that your liability insurance coverage applies to livestock hit on the roadway. I know somebody not too long ago who had an animal get hit on a road. He calls his insurance carrier and they say, oh, you don't have that kind of coverage with your policy. Make sure if you've got livestock, you confirm that coverage. Okay, so with that background, let's go back to Garcia versus Pruski. All right, and again, we've got the bull that got hit on the highway in Wilson County. Here's where things got interesting. Here you had a state highway, which we know has that knowingly permit standard, and it was also in a stock or a county with a stock law, which has a permit standard. So everybody agrees it was closed range, but the fight was about which standard applied. The owner of the bull said it should be that higher knowingly permit standard because that's harder for a plaintiff to prove, and he was on a state highway. The motorist argued it should be that lower Wilson County permit standard because that applies in the entire county. So we left it up to the Texas Supreme Court to give us the answer. The case ended up there, and the verdict is the case was dismissed the court said that it is only that higher knowingly permit standard that would apply. And under the facts here, right, no cattle out, good fences, the gate was latched, no history of issues, the landowner didn't knowingly permit the bull to run at large. He did get out, but the landowner didn't rise to the level of knowingly permit. Okay, so this was a hugely important case. Eric mentioned that STPRA filed an amicus brief, and that's because determining which standard applies in counties with stock laws if accidents occur on state highways is a big deal, because that can affect a lot of counties here in Texas. Okay, so that's the Garcia versus Prusky case. The next case I want to talk about is called James versus Young. And this case is going to involve the Texas Farm Animal Liability Act. Okay, the James versus Young case came out of the Waco Court of Appeals a couple of years ago. And what happened there is the Young family owned a ranch, and they invited the James family to come over. They were there for the day. For a good part of the day, the men were working cattle. At the end of that time, kind of in the afternoon, the cattle were all tied, the horses were all tied up on the fence near the cattle pens. And the Jameses had a 6-year-old child who wanted to ride a horse. So they pulled 2 horses off the fence that belonged to the Young family, right? So they belonged to the owner of the ranch. They put the 6-year-old on one, another kid on the other, told them to ride down the road to the gasoline tanks, and when you get there, turn around and come back. So the kids ride down there, no problem. They turn around to come home. What happens? We got barn sour horses, right? They start running. The 6-year-old gets bucked off and is injured. And so the James family files a lawsuit against the Youngs, okay? So injured kid files a lawsuit against the ranch owners claiming negligence, okay? That the ranch owners were negligent in allowing that child to get on the horse. As a defense, okay, the ranch owner raises the Texas Farm Animal Liability Act. And in doing that, they sought dismissal of the case. Okay, so what the Texas Farm Animal Liability Act does is it basically says if there is an accident that occurs during a farm animal activity, and the accident is the result of an inherent risk of that farm animal activity, the animal owner is not liable. And this is kind of the scenario here is the classic example, right? When you crawl on a horse, there's an inherent risk you could get bucked off. And so if the Farm Animal Liability Act is found applicable, the case gets dismissed. Now the plaintiffs in turn claim that there's one of the exceptions of that Farm Animal Liability Act that applies. And so what the exception says is that despite the Farm Animal Liability Act, a defendant can be liable if they provided an animal to the person and did not make a reasonable and prudent effort to determine the ability of the participant to safely engage in the activity and to safely manage the animal. So that's the question that's going to be right before the Waco Court of Appeals. Did the landowner provide an animal to the 6-year-old without making a reasonable and prudent effort to determine the ability of the kid to safely engage in the activity and safely manage the animal? If the exception applies, the case goes forward and they can go on to a jury. If the exception does not apply, the case gets dismissed because of the defense of the Farm Animal Liability Act. So what do you think? Does the case go forward or get dismissed? Okay, there's just a summary of the act. We talked through those points. The trial court and the Waco Court of Appeals both sided with the ranch owner and decided to dismiss that case, okay? And what they found there was, listen, the Farm Animal Liability Act does apply, okay? Getting bucked off a horse is an inherent risk of a farm animal activity. And they said that the exception did not apply, and I think that the biggest reason was because his parents were standing there, right? the injured child, his mom and dad stood there. They let him get on the horse. They didn't say anything. They didn't object. Those were pretty bad facts for the plaintiff. There was also testimony that this kid grew up on a ranch as well, owned his own horse, and had ridden countless times. So the case got dismissed. So a very good statute for you to be aware of if you have any sort of horses, livestock, etc. This is a really important protection. A couple of limitations on that statutory protection. The first thing is the defense applies only if the injured party is a participant in the farm animal activity. So for example, we've seen this come up at rodeos or barrel races before. If the person who got injured was a participant in the activity, right, a barrel racer, then the statute could potentially apply as a defense for the rodeo organizers. If the person that got injured was a spectator at the event, right, like a horse gets loose and tramples somebody in the bleachers or walking by the arena, now the statute doesn't apply. So there's that participant limitation. There's also at least an open question in Texas law about whether this applies if the injured person is an employee or an independent contractor. The Texas Supreme Court has not ruled on this, but several lower courts have said that the defense is inapplicable if the injured party is an employee, but it may apply if the injured party is an independent contractor. We don't have time to get into the details of that today, but just keep that limitation in mind. The last thing that I'll note is if you're a farm animal professional, you have to hang up a sign. That's going to be somebody who's engaged in an activity for compensation where you rent somebody an animal, equipment, or tack. So if you're doing riding lessons or you've got a boarding stable, you're going to need to hang up that Equine Act sign. If you're just a regular person like me who's got cattle and horses and people come over to our house, you don't have to have the sign to get the protection. Okay, the last case I want to talk about is really recent. It came out within the last month or so from the Texas Supreme Court. It's called Hillis versus McCall. And in this case, a tenant got bit by a brown recluse spider inside of a hill country kind of hunting cabin bed and breakfast. So the tenant lives on the property, goes in to like open up this hunting cabin that they lease out on weekends, gets bit by the brown recluse. The tenant files a premises liability suit against the landowner, basically saying that the landowner violated his legal duty to warn or protect the tenant from the spider. So the landowner seeks dismissal of the case and basically argues that he had no knowledge of spiders being on the property, and Texas law doesn't require a landowner to be liable for wild animal injuries. And that's true. So generally, a landowner is not going to be liable for things like spiders, snakes, scorpions, wasps, etc. Okay? So what's the verdict? Right? Do we think the landowner is liable here or not? We're not going to have time to get through all the details here. What's important for you to know is this doctrine called Freire Naturae says that Texas landowners are generally not liable for wild animals unless, so there are kind of three ways you can be liable. If you introduce the animal to the property, so I guess here if the landowner had brought the spider in and turned him loose, he could have been liable. If you've reduced the animal to your possession, so, you know, I guess like let's say that the landowner, there were snakes on the property and he like captured them up and had a snake den where he had people come out and they had some sort of rattlesnake roundup. You can be liable there, okay? The third thing is if the injury occurs inside of an artificial structure and the landowner knew or should have known and you could not have expected the injured party to know. Okay, so that's sort of the background that the court used in the case. And the Texas Supreme Court here sided with the landowner and dismissed the lawsuit. Kind of two big reasons. The first one was that there was just no evidence that landowner had any specific knowledge of venomous spiders on the property. He didn't know, right? He didn't bring them on the property. He did not get them in his possession. So he did not have that knowledge. The second thing is that there's no evidence that the landowner would have had any more knowledge than the plaintiff. In other words, the duty for landowners really is to warn people about dangerous conditions they can't observe themselves. Here, the plaintiff could have seen that spider just like anybody else. So that kind of comes into play. Again, Chris is going to talk about this. Liability insurance is super important, and one reason for that is it provides you a defense. So in this case, right, if the landowner had liability insurance, he would have turned the defense of his case over to his insurance company, which means he didn't have to pay the lawyer bills out of pocket. The insurance company paid them. And let me just tell you, to get a case through a trial, appealed all the way to this Texas Supreme Court and get a verdict, that's hundreds of thousands of dollars. That again, hopefully he had insurance to pay for that rather than it coming out of his own pocket. One last note on this, do keep in mind the standard of care is different for trespassers. Eric mentioned this a little bit at the beginning. This case involves somebody who's on the property with permission, who is doing something for the landowner. That's a much higher standard of care. If the injured party here had been somebody who was not on the property with permission, right? If they had come on the property without knowledge and permission of the landowner, then the duty owed is even lower. The landowner does not have a duty to warn of dangerous conditions. All they have to do is not act intentionally or with gross negligence. So I'm happy to answer any questions on that. I just wanted to put that out there. Don't worry about spiders and trespassers on your property because of this case. Okay, the last thing is just a couple of extra resources from me if you're interested in those. I do a couple of courses around the state each year. The first course is called Owning Your Piece of Texas. It's essentially a day-long program on the key laws that ag landowners need to know. We cover everything from fence law to water law, eminent domain, different topics like that, including landowner liability. That class is, we do it in person. It's $75. There's the information on the dates. Pending Corona craziness, we're sure hoping to have those events this fall. Other set of classes, that says 2019, I'm sorry, it should say 2020. Our leasing workshops, those are events, half-day programs that really focus in on legal issues and drafting good grazing, hunting, and livestock leases. So if you're interested in those, we've got live programs at 4 locations this fall. We also have an online course that you can access anytime. The cost for that one is $75, but you can go in and watch as many times as you want. You can go at your own pace. So that's an option if you're interested. Contact me and I'll get you the info for how to sign up. To go along with that Owning Your Piece of Texas course, we have a handbook. It's about 15 chapters long, and it just gives you an overview of kind of all the key laws for Texas landowners. If you want to download a copy, that's free, and I'm going to show you how to do that on the next slide. If you want a hard copy, we have to charge for those just because of printing and mailing. They cost $30, and you can call that phone number there to get a copy ordered, or you can always shoot me an email and I'll help you get that done. So this is my blog that Eric mentioned earlier. It's called the Texas Agriculture Law Blog. You can just Google that and get there. Anything I do gets posted here. So when a new case comes out, I'm going to do a blog. You know, if new regulations, if I do checklists or handbooks, they all get posted here. So if you're interested in that, when you go to that website, a little window will pop up where you can enter your email address. If you do that, my posts will come to you just like an email, so you don't have to remember to go check. Additionally, this is where you can find the PDF free versions of all my handbooks. If you just go to that tab that says Publish Materials, you can find those there. Last thing, Eric mentioned my podcast. I just interview an ag lawyer on a different topic every episode. We are up to number 80 now. So if you're interested in that, please check it out. It's free. You can listen anywhere you listen to podcasts, iTunes, the podcast app, or you can listen on your computer. All you've got to do is type in that address there at the top, aglaw.libsyn.com. It'll pull up the page and you can just push play on whatever episode you want. It's just audio, no video, so feel free to listen in on those conversations. The last slide here just has all of my contact info. Right now, because of COVID, the best place to contact me is by email, tdowell@tamu.edu. I'm also on social media, Twitter and Facebook, so feel free to contact me there as well. So with that, I will turn it back to Eric, and then I'll stick around, listen to Chris, and be happy to take questions at the end.
Thank you so much, Tiffany, for this great review of the top 3 cases dealing with landowner liability. Our next presenter is Chris McAllister. He's a field underwriter supervisor for Texas Farm Bureau Insurance Company. Chris has been with Texas Farm Bureau Insurance for 10 years. He began his career at Texas Farm Bureau as an all-lines claims adjuster in South Texas before moving to the underwriting department. As field underwriter supervisor, he leads a team of 8 field underwriters located throughout Texas that are tasked with loss control responsibilities, as well as conducting commercial, residential, farm, and ranch property inspections. Chris resides in Central Texas with his wife and 2 children. It's great to have the perspective of both a lawyer who's litigated those cases and studies these cases, and then the practical person on the ground who assists landowners in protecting their assets against some of these liability claims. Thank you so much for being with us here, Chris. And just a reminder, if you have questions, type them into the chat box. We've already had 2 that have been posted in there waiting to be answered at the end of the presentation. We'll get to those at the end of our presentation. Take it away, Chris.
Eric, thank you so much for the kind introduction. Good morning, everybody out there. My name is Chris McAllister. I'm the field underwriting supervisor with Texas Farm Bureau Insurance Company. I want to start by telling Tiffany that was a great presentation, great information. You are a well-known and highly respected voice in Texas ag law. We appreciate all you do for landowners and all people across the great state of Texas. And of course, thanks to the South Texas Property Rights Association for hosting this event and inviting me to participate in the webinar today. Most importantly, thank you everyone in the audience for joining us, taking time out of your busy schedules and being here with us today. And again, as Eric mentioned, don't forget to submit questions in the chat box. We will do our best to get to those at the end of the presentation. And if there's anything that I can't get answered or that we can't answer today, I will follow up with you and get that done. So getting started here, we're going to be talking a little bit about farm and ranch liability, recreational land use, and insurance. Just some of the common type things that you'll see out there as a landowner. Of course, I have to read the disclaimer to make all the folks back at the home office happy. This presentation is intended only for South Texas Property Rights Association webinar attendees. No copy or use of this presentation should occur without the permission of Texas Farm Bureau Insurance Companies. The information contained in this presentation is solely an educational tool that is general in nature. It is not intended to be a substitute for advice of insurance advisors. It is not intended as a legal advice, and it is not a substitute for advice of counsel. You should always check with your own insurance advisor and legal advisors for interpretations of the legal and compliance principles applicable to your business. Texas Farm Bureau Insurance Companies make no claim, promise, or guarantee of any kind about the accuracy, completeness, or adequacy of the content of the presentation, and in no event shall Texas Farm Bureau Insurance Companies be liable for any direct, indirect, incidental, punitive, or consequential damages of any kind whatsoever with respect to the presentation and the materials. All right, now that we've checked that box, I've made those folks back at Illegal happy. Let's get on to the good stuff here. Farm and ranch liability loss exposures. Let's get too far ahead. Okay, here we go. This is what we're going to be talking about today. Farm and ranch liability loss exposures, recreational land use, and insurance issues. As a landowner, one of the challenges you should be keenly aware of are farm and ranch liability exposures. The better prepared one is to address these liability issues through insurance and other preventative measures, the more likely they are to be successful in achieving the goal of a lasting legacy. As landowners, you are exposed to numerous liability concerns, as well as owing a variety of duties to those who enter your property. Today, we will look at some of the common farm and ranch liability exposures that many of you routinely encounter. Also, we will review information regarding the recreational land use statute. We will wrap everything up by discussing how insurance can assist you in protecting your legacy. Liability losses can be especially costly and lengthy, as most liability cases end up with a drawn-out legal process. The downtime can wreak havoc on your operations. Liability losses negatively affect more than your financial situation and your overall well-being by consuming your time and energy. Ultimately, these losses can end up having a lasting effect on your reputation as well as your legacy. So we need to be prepared. We need to protect that legacy. A vital step to ensuring that the liability exposures unique to you and your operations are minimized is to work with your legal advisor and a licensed insurance professional. Have them out to your location, your property, your farm, spend time with them, review your specific situation. Every case is unique. Discuss all the operations activities that take place on your land. It's important to discuss your ownership structure, lay out the details of your ownership structure to avoid gaps in coverage. If you have multiple entities, it's owned under an LLC, there's different ownerships. Get all this ironed out with these folks. Your time and efforts with this process will give you confidence that you have a comprehensive plan in place to assist in protecting your legacy. Okay, so moving on here, farm and ranch liability loss exposures. Farm and ranch liability loss exposures may be especially hazardous to youth and children, older adults, and the alcohol or drug impaired. Negligence. There are many types of liability. We will mostly be talking about negligence. It's important to understand the definition of negligence. Negligence is a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. The behavior usually consists of actions, but can also consist of omissions when there is some duty to act. But take notice of the acts and omissions. The failure to act and correct a known hazard is just as bad. Farm and ranch liability loss exposures. This is as it pertains mostly to your premises and operations. These are very common. Livestock and fencing, who is on your land, attractive nuisance, no trespassing, pollution, mobile farm equipment, and employees. And we're going to get in more depth into all these factors as we move forward. Livestock and fencing. Isn't that true, folks? The grass is always greener. At least the cattle always think so. More livestock and fencing. Does your fence meet minimum requirements to contain type of livestock or other species confined? This pertains to dairy cows versus newly purchased cattle, livestock versus buffaloes versus emus. They've got llamas and goats and all those great animals that you've got confined. Electric challenges with grounding your electric wires. Cattle guards. Let's make sure cattle guards are clear of debris. We should inspect these cattle guards routinely. Water gaps, locked gates, know who's coming in and out of your property. We've seen it happen multiple times. Cow escapes from the back pasture that was accidentally left open, or thought was closed but forgot to lock, or maybe that locking mechanism fails. And what happens to that cow? But man, it sure does always manage to find its way to a busy road. Livestock and fencing. Keys to good fences. Regular inspections are vital. Ongoing maintenance. Make sure your cattle guards are cleaned out. Water gaps inspected. Brush control in fence rows is something we see a lot of that needs to be managed. Fence checks are a necessity though, especially along highly traveled roadways or highways or any other area of concern. Also, if you need to perform these routinely, but it's also important to perform them maybe after a recent storm. Storms around water gaps or wooded areas, maybe a potential of a tree fell on the fence and knocked it down. The wind could have blown down some posts. Always be mindful of your surroundings and the environment, and be regular and routine with these fence inspections. And here we go. Here's a fence that makes an insurance man happy. A nice, tight 5-strand barbed wire. Got our fence posts straight and secure. I'd walk up to this fence and leave there with a big smile on my face. And here we go. Here's another example of a good fence here with a breakaway hinged water gap. Probably not something we see a lot down there in South Texas, but again, you can see some nice straight posts here, along with some good straight wire, tight wire. And there's always the one cow that, despite your best efforts, seems to have magical powers, finds some magical hole that you didn't know existed. But your consistency in your fence checks and your maintenance, you can stop this special magical animal. Livestock and fencing, other fencing issues. Know your situation. Your owned acreage for your operation. Are you leasing land to a third party? Do you lease land from a third party? There are different situations that are going to bring different responsibilities. As Tiffany mentioned, know your area stock laws, open versus closed range. This is all great information, all vital to you running a successful operation. Continuing with the fencing issues, who's responsible for the fence upkeep? For leases, written or verbal, you and a third party could be held jointly liable as joint tortfeasors. Here's a little more legal jargon for you. What is a joint tortfeasor? Two or more people whose negligence in a single event causes damages to another person. And in many cases, the joint tortfeasors are jointly and severally liable for the damages. Now, I know Tiffany can explain more, but jointly and severally, very important. Meaning, okay, back to the definition. Jointly and severally liable for the damages, meaning that any of them can be responsible to pay the entire amount, no matter how unequal the negligence of each party was. Who is on your land? Who's on your land and what level of care do you owe them? I know Tiffany talked a little bit about trespassers. I'm going to focus some more on invitees here, who you owe the highest degree of care of, and who most likely is going to be entering your property. An invitee, you owe the highest degree of care. They are invited to your land as a member of the public or for a business reason. Requires reasonable inspection to uncover hidden dangers and duty to warn of known and hidden dangers. So folks, think about if you're having your grandparents or maybe a niece or nephew out to your property, you want to keep it safe, as safe for your infant nephew as you would for your grandparent. If you have a staircase out there that has a rotten railing, or if you know that there's steps on the stairs that are about to fail, but you continue to have folks walk up and down these stairs, that would be something that would get you and could get you in a heap of trouble. So be mindful of these things. Be mindful of your steps and walkways. Be mindful of clear walkways. Slip and fall claims and liability claims of these slip and fall natures don't only occur at supermarkets and feed stores. They can also occur on your personal property. Attractive nuisance. What is an attractive nuisance? It's a hazardous object or condition on the land likely to attract children who are unable to appreciate the risk posed by the object or condition. An exception of premises liability claims are applied to trespassers because child trespassers may not appreciate the risks that the dangerous condition poses. Landowners have the duty to either eliminate that danger or make it inaccessible to trespassing children. This has been applied for injuries caused by swimming pools, playground equipment out front, trampolines out front, sand piles out front, lumber piles. And you can see in the next picture, even abandoned buildings can be considered an attractive nuisance. So here we have our good old South Texas swimming pool in the front yard, folks. Let's keep those in the backyard and let's keep fences around them. This would be considered an attractive nuisance, something that anyone, especially a child, could walk up to and potentially have an accident. So let's be smart about that. No trespassing. Now, I've seen a lot of these doing a great Texas tradition, floating the Frio or Sabinal River. In the summer times, you see these trees have the purple markings on them. Well, folks, that means no trespassing. Generally, no trespassing signs or markers are purple vertical lines not less than 8 inches in length and not less than 1 inch in width. They should be placed so the bottom of the mark is not less than 3 feet from the ground or more than 5 feet from the ground. And it's important to space them properly. You want them no more than 100 feet apart on forest land or 1,000 feet apart on land other than forest land or visible presence on property of a crop under cultivation. So post those no trespassing signs. And I know not to get out of my tube when I see these, just to keep on floating. Pollution. Let's talk a little bit about pollution now. Most farm and ranch liability policies contain an absolute pollution exclusion, providing little or no first and or third party coverage for pollution related incidents. However, some insurance companies now have a pollution endorsement that you can add to your policy. Now, for insurance purposes, let's kind of look at the definition of a pollution incident. Generally, a pollution incident would be any above ground contact with agricultural pollutants which have accidentally discharged, dispersed, migrated, released, or escaped. So just a little bit of background there about what a pollution incident would incur. Pollution exposures exist for pollution and cleanup exposures for farming and ranching operations, including but not limited to your concentrated animal feeding operations, your CAFO, animal waste containment and odor, and chemical drift or overspray. I want to back up to the odor point there. And recently, in Henderson County, Texas, there was a class action lawsuit against Sanderson Farms, in which they were, which resulted in a $6 million award to surrounding residents for, among other things, a persistent nuisance odor. So, folks, urbanization is happening all around us, and this is just a prime example of a maybe an overseen liability issue that turned out to be quite costly. So in this lawsuit, the landowners were also named. Chemical and fuel storage. You want to keep your farm and ranch chemicals stored in a non-combustible building over a concrete slab. It needs to have the ability to lock the building, and a wash station and water supply is also preferred. Here you can see what we consider a chemical storage area with your 2,4-D weed killer here. Chemicals and farm storage continued. Your private pesticide applicator license, keep that current. Do you need adequate supervision? Are you adequately supervising those spraying for you? Are you following your material safety and data sheets? Never stray from the intended use of the chemicals that you're utilizing. Chemical drift. Know your neighboring crops, and chemical drift coverage or protection would provide you an aggregate limit for those sums you become legally obligated to pay as damage for physical injury to crops or animals. Now, I know those of you that operate spray machines or do any kind of spraying are vigilant about spraying in the correct conditions, and again, utilizing the chemical you're spraying to its intended purpose. Record keeping is another important aspect of any of this type of operation. You want to keep clean, accurate records. You can keep them digitally, you can keep them the old-fashioned ways, but keeping records is important. You want to keep your chemicals secured and locked again, and properly placed no smoking signs is often overlooked, but in general is a great idea. Okay, we're going to move on to some mobile farm equipment information now, and slow-moving vehicle emblems. Now, accidents involving farm equipment on rural and urban roads have shown a slight increase since 2011. And again, your normal farm-to-market road that maybe had 1 or 2 cars on it back in the day now can be heavily traveled. You got Uber or Lyft or whoever it is driving these roads that aren't familiar. And folks, it's more important than ever to be visible and be alert while we're operating our mobile farm equipment on these roads. Again, I'm sure most of you know, but the slow-moving vehicle emblem is a universal symbol for anything traveling 25 miles per hour or less. They are required by state law. They are required by OSHA if it's employee-operated machinery. They should be placed 2 to 6 feet from the ground. They should be clean and visible. They should be replaced when they fade. And a big pet peeve of one of my colleagues in East Texas is don't use them as a driveway entrance marker. Don't hang them up on your fence. Again, only for its intended use. Let's keep them on the machinery and off our fence posts. Mobile farm equipment continued. Again, distracted drivers are everywhere. Now is more important than ever to be visible and be alert. Your lighting is extremely important. This is from some information from the Department of Insurance Division of Workers' Compensation Safety Workplace flyer titled Farm Tractor Road Safety. Farm tractors are required to have 2 forward-facing headlights and a red taillight that burns continuously, taillight must be visible for 500 feet under normal conditions and mounted on the far left side of the tractor. Towed equipment requires 2 rear-mounted red reflectors positioned at the extreme left and right. Farm tractors and equipment require hazard warning lights or flashers when operating on public roads. White or amber flashers are mounted on the front and red or amber on the rear. These lights must be activated when the vehicle is in operation. Folks, be visible and be smart when you're operating. Conduct a walk around before you get in your implement to drive it and move it to the next location. You never know if there may be a car parked behind you or an electrical wire in front of you. You never know. Always conduct a walk around before you get in. A trailer spotter vehicle is always a great idea. If possible, move your equipment in daylight during periods of light traffic. Of course, that would be the ideal scenario. And farm tractors and equipment operating on public roads must obey all traffic lights and signs. Here's a good example, folks, of how quickly you need to react when it comes to differences in speed. As you can see in example A, the rear car traveling 55 miles per hour has approximately 27 seconds closure to the other car, whereas the tractor operating at 15 miles per hour with the vehicle traveling from behind at 55 miles per hour has less than 7 seconds. How important is it to know that that vehicle behind you is going to see you? These types of accidents can be deadly. So let's be smart about this, and let's make sure that we're operating in a responsible and safe manner, and that we are well seen when we're operating on roadways. Let's talk a little bit about employees now. Employees can be a vital aspect of your operations. There's some information from the Bureau of Labor Statistics and CDC. The Bureau of Labor Statistics states in 2014, farmers, ranchers, and other agricultural managers comprise those of working the 6th most dangerous job in the U.S. And that's from the Bureau of Labor and Statistics. As you can see here, folks, if you can see in the picture here, that's not OSHA approved, I would think, as far as face protection. So I would think that would probably not fly in the long run. A little more information about employees. Approximately 2,038,000 full-time workers were employed in production agriculture in the U.S. in 2018. Approximately 1.4 to 2.1 million hired crop workers are employed annually on crop farms in the U.S. An estimated 893,000 youth under 20 years of age resided on farms in 2014, with about 454,000 youth performing farm work. Every day, about 100 agricultural workers suffer a lost work time injury. From 2008 to 2010, 50% of all hired crop worker injuries were classified as a sprain or strain, and an estimated 12,000 youth were injured on farm. 4,000 of these injuries were due to farm work. Again, agriculture and farming in general is dangerous, and employees and training is important. So we need to make sure that we are doing everything we can to provide a good example to our employees, provide adequate training to our employees, and that we're hiring the correct employees. As it pertains to employees, vicarious liability is something where you can be held liable for the actions or omissions of your employees during their course of employment. Okay, or do you have an adequate hiring process? Are you hiring the right people? Do they have clean records? Do they have valid driver's license? Do they know motor vehicle laws? Are they driving your vehicles? Are you performing motor vehicle record checks? Do you perform drug and safety checks or tests? Do you have adequate safety plans in place? Again, training is vital. Do you conduct regular safety meetings? We at Texas Farm Bureau Insurance Company are big proponents of tailgate training. And that could be something as simple as getting together and talking about how to operate a forklift to something as complicated as spraying, conducting a successful spray operation. But in general, the more time you spend with your employees to go over these important factors, to know that how you want them to run your operation is important. Take the time, invest that time in them. And again, remember, employer's liability is not workers' compensation. Okay, recreational land use. Now we get into some of the fun stuff and really the reason why we all live in this great state of Texas. How am I doing on time? Okay, I'm about to right now. I'm going to zoom through this real quick. This is all pretty self-explanatory. It can be found on your website here, Texas Recreational Land Use Statute. Here you go. Get my boy back there in the background reeling in a big bass at the ranch. Again, some more information on recreational land use. Important to know what qualifies as recreational land use and to review this information. Again, this can all be found online. So just look for that online and all this information will be available for you. It's very easy to find. Here's some examples of what recreation as an activity means. Important to know, outdoor weddings do not qualify as recreational land use. Courts have found that recreational land use does not include outdoor weddings. A commercial general liability policy is needed. Keep this in mind for other events you host. If you do, maybe you have an old converted barn or something of that nature, you will need a separate general liability policy or event insurance. So be mindful. These are things you'd want to talk about with your insurance professional and your legal advisor. Recommendations here. Big recommendation that Tiffany mentioned, hold harmless agreements. They're important. Utilize them, have one drawn up with your attorney, and utilize those as you see fit. Okay, what about insurance? Here we go to the good part. Your goals is to prevent losses from occurring in the first place, right? And we want to do the same thing. So we want to reduce the frequency and severity of losses. We want to identify the hazards. And your insurance company can assist you. At Texas Farm Bureau Insurance Company, we have a loss control department, and we are actually in the process of updating and getting some new materials for our loss control. So this is something that insurance companies can and will assist with. Keep that in mind as you move forward to discuss things with your insurance professional. Okay, a liability loss exposure might give rise to a claim for damages against a person or business for negligence or wrongdoings. As Tiffany mentioned, lawsuits can be costly, hundreds of thousands of dollars. Protect yourself with liability insurance. Some of these things that you wouldn't think need to go to lawsuit end up taking years to settle. So be mindful of that. And again, personal injury. What is personal injury? In insurance refers to injury other than bodily injury and includes defamation, such as libel and slander, false imprisonment, false eviction, and similar actions. Okay, here we go. Finally, I think we're wrapping it up here. Keep your insurance company apprised of any new activity or service that was not present when you purchased the policy. If you change your operations, notify your insurance company immediately. Every insurance company has its own underwriting guidelines. Make sure your insurance company is aware of all new activities. The policy you have may not provide coverage for your new exposures. Schedule yearly reviews. Sit down with your insurance professional. Sit down with your legal advisor. Get this all ironed out, folks. I'm going to go ahead and wrap that up now. I had a closing, but I went too long, and I apologize for that. So, folks, if you have any other questions or anything anything I can help you with after the presentation, please seek me out. Again, my name is Chris McAllister. I'm the Field Underwriter Supervisor with Texas Farm Bureau Insurance. Thank you so much for your time today, and look forward to working with you in the future.
Thank you so much, Chris. That was a action-packed presentation, and I appreciate you presenting to us today. We have a couple of questions that have been presented by viewers, and I also want to note that if you do have questions, you can put them in the chat box, and we'll make our best efforts to answer them in the time we have remaining. The first question was actually emailed in. You could do that too, but we're running a little short on time, so try to do it in the chat box. Toddy Burns asks, what are the rules and recommendations for setting up gasoline and diesel tanks for ranchers? We have 3 tanks for diesel, gas, and off-road diesel, and I bet other ranchers do too. I have no idea what the answer is, so I thought I'd forward it to you, and maybe you could mention it. I'm not talking about spills, I'm talking about safety. Chris, could you answer that for us?
Yes, Eric, sorry about that. I had it on mute again. Yes, well, there's no, unfortunately, clear-cut answer to that question because there are different regulations and different items, required by TCEQ. But in general, when it comes to safely installing or utilizing an above-ground storage tank, we're going to require a support structure that is built on level ground with solid foundation. We need to make sure that foundation has enough weight to support the combined weight of the tank and the chemicals you're going to put on it. Add additional bracing if needed. Another thing we look for is place tanks in a location that's not heavily trafficked. Don't place the tanks where you're going to be driving vehicles or implements near it regularly to avoid a collision. Containment is always a great way to limit pollution incidents. So if you can have some sort of containment area for the tanks would be great. Another thing that we look for as an insurance company, I know he mentioned he's not worried about spills, but having a spill, an SPCC, which is a spill prevention, control, and countermeasure plan, is vital. These can be of a formal or informal nature, but in general, you want to have some sort of plan in place, and insurance companies will look for you to have this plan in place in the event of a spill. I would suggest different areas will have different rules, but in general, that should cover you as far as a safe installation of an above ground petroleum storage tanks.
And Tiffany, do you have anything to add?
Yeah, of course, the lawyer is going to cite a regulation to you. The TCEQ does have some regulations. If I were this person asking the question, I'd go to their website. Specifically, if your tank is 1,100. If your tank is 1,100 gallons or larger, you are regulated by those TCEQ regulations. So I'd sure take a look at that depending on the size of your tank.
Okay. Great question and great answer as well for y'all. We have another question from Bill Guerra. And he asks, if he has someone helping him work cattle, day help, and gets hurt by an animal, what's his liability? Tiffany, could you help us with that one?
Yeah, Bill, that's a great question. The answer is likely that's where that Animal Liability Act is going to come into play. Working cattle, you've got folks out there that are employees, right? Maybe they're just day workers that would likely be independent contractors. That statute says if the injury happens based on an inherent risk of a farm animal activity, you're not liable. Strikes me as a pretty good sell. Get injured working cattle, right? I think we've all gotten kicked or whatever. And so I sure think that Farm Animal Liability Act is a great defense for you. The other protection that you've got in that scenario would be your liability insurance. Again, that provides you a defense, potentially helps you up to the policy limit. But that's where that statute I think is really effective and could be helpful.
Okay, Chris, do you have something to add?
Yeah, I agree with Tiffany there. If you have an employer liability policy or workers' compensation policy, you would have some type of coverage there. We get this question often as far as injured persons. Are they an employee? Or are they just a one-time? Is it just a friend helping? So there's a variety of angles and things to consider when it comes to this injured individual. Let's say it's an employee who the insured pays for his services. There generally would be no coverage, but in some instances, you will see insurance companies pay what we consider medical pay, and generally that has a liability of $5,000. Now, let's say he's a friend or a one-time helper. That's going to fall back to negligence. What was the cause of the accident? So again, there's a lot of moving parts there, but hopefully that helps a little bit. Insurance is important, though. Have that insurance.
Okay, Susan asks, prescribed burning insurance is hard to find. Is there any coverage out there? Can you help with that, Chris, since you're the insurance guy?
Yes, I have actually asked about that recently and getting some more information on our prescribed burn and how it pertains to our policies. If I could get that individual to contact me directly, I would be able to eventually get them an answer on that. But unfortunately, I don't have one at the moment. So Eric, if you can do something to facilitate, I would love to try and help them out with that and answer that question for them.
I'll definitely do that. And Tiffany, do you have anything to add?
Yeah, I'll chime in just briefly. I've got a fact sheet that I did with Dr. Morgan Treadwell out at St. Angelo, who does a lot of prescribed burning work that actually talks about liability and insurance for prescribed burns. One thing in that statute that Morgan pulled together was looking at various different farm and ranch policies from different companies and their liability coverage for prescribed burns. So if you want to get a copy of that, that'll give you kind of an idea of what companies have and don't have kind of in their standard policies. The other thing I would mention is Texas does have a limited liability statute for prescribed burns if you take certain steps. We explain that in that fact sheet as well. I would make sure and take a look at that because you sure want that limited liability if you're going to be burning on your property.
Okay. Well, we're running short on time today. We'll definitely get that question answered as well. Talking about other pamphlets are available. STPRA has a pamphlet prepared by another attorney in agricultural law, Jim Bradbury, keeping liability outside the fence. We're going to email that to everyone that participated in the seminar today so you can have a reference that addresses a number of the landowner liability concerns that were addressed today. This presentation will also be posted on our website and be available for you to keep. Finally, we have a survey that's going out. This is the first webinar that we put on as an association with this new situation that we're in with restriction is in-person meetings. Normally we have ranch gatherings where we have these in-person presentations. We want your input on whether this was beneficial to you, whether the technology worked, and we're learning along with you in this new situation that we're in as a nation and frankly a world. Hopefully we've given you some answers on how to limit your liability as a landowner, and we appreciate your participation in our presentation today. Have a good day and stay safe. Goodbye.